Well, let's jump into it. And my name is Cory Parnell. I'm a principal at BGM, and we are MGI, North American firm as well. And I'm excited about today's conversation around the buy-sell agreement. And our two experts that are joining us today is Dyanne Ross-Hanson. She's been succession exit planning for 20 plus years. Does a great job working with business owners on very challenging and difficult subject at times, but always the ability to get a great plan pulled together, not just for the owner, but the owner and their family and other business partners. And then also we have Rob joining us from FMJ law firm here in Minneapolis. Rob's been with the firm for 4+ years, works with clients in many areas from general corporate structure as well as M&A deals. And just very excited about this conversation. So maybe Rob, if you want to just kick us off, how did this subject surface today about buy-sell?
Thanks, Cory. So today I'm here to talk to you about a recent Supreme Court decision, which was released back in June of last year. Case is Connelly versus United States. Long and short of it is the Supreme Court, in a unanimous decision, a rare unanimous decision, determined that the value of corporate shares for estate planning and estate tax purposes, the value of that corporate-owned life insurance policy on the shareholder who died is not offset by the corporation's obligation to redeem those shares from the estate. Now, this has wide-ranging implications for privately held business owners. And I'm going to go through kind of the nuts and bolts of the case. But at a high level, the overarching view of this is if you have a buy-sell agreement, if you have multiple owners in a privately held business, you need to be focused on what the Supreme Court ruled in this case, because if you are not paying attention and you don't subsequently review and ensure that your docs are up to date, you can get hit with a very large estate tax bill. So what we're going to talk about, I'm going to talk through the kind of specific details of the case at a pretty high level. And if anyone has any questions, feel free to drop a question in the Q&A. But basically, the case follows from Crown Supply, Inc., which was a successful small contracting business owned by two brothers, Michael and Thomas Connelly. Now, the shares were unequally split between the two brothers. Michael owned 77%, Thomas owned 23%. So they had a cross purchase agreement among the brothers that said if one of them died, the other would be permitted to buy the other brother's shares from the estate. Now, importantly, in that cross purchase agreement among the brothers, they had reduced the amount to the value of the life insurance policy, which was $3.5 million. When Michael ultimately passed away, Thomas, the other brother, decided not to purchase the brother's 77% of equity ownership in the company. Now, the company then stepped in and used the $3 million in life insurance policy proceeds to purchase his shares from the deceased brother's estate. Ultimately, the IRS took a different view and said that the cash that was the life insurance proceeds should be included in the value of the company for purposes of calculating the deceased brother's estate tax. I know that is a lot of kind of downstream detail, but ultimately the Supreme Court ruled that it was in fact proper to include that life insurance value in the deceased brother's estate plan because, and this is important, because it appeared as if they had arbitrarily picked a lower than fair market value number for the redemption purchase price. Now, Dyanne's going to walk you through later on in this conversation a number of strategies to basically deal with this change, because prior to this decision from the Supreme Court, business owners in the privately held context had been basically using this scheme or plan for many decades without interruption, without issue. So the Supreme Court decision represents a material change for privately owned businesses and an individual who owns part of a privately owned business. It represents a massive sea change in the rules that apply. I'm not sure if anyone wants me to go into further detail on the case, but I think, at a high level, once again, the overarching idea here is if you have a privately held business, you have company-owned or individual-owned life insurance that is going to be used to fund a buyout upon one of the owner's death. You need to talk to your professional counsel folks and make sure that the way that you set up your buy-sell agreement complies with this rule, the way that you've got any life insurance structured appropriately to make sure that you're not going to get hit with the $3 million tax hit that the Connelly brother, who passed away, his estate was hit with an incremental estate plan tax, which, I think $3 million is pretty material for anybody on this call.
Yeah, thanks, Rob. And great thing I forgot to mention, this is an interactive webinar. So if you do have questions, please ask them, and then either we'll get to them at the time that they're asked, or if we think they'll be covered later. So definitely, please ask your questions as you come along. And I think one of the core things on this subject is if you have a buy-sell agreement, you have a partnership, you don't have a buy-sell agreement, but more importantly, if you do have a buy-sell agreement, how important it is to review it on a regular basis. But with that said, I'm gonna pivot over to Dyanne. If you could kind of talk about the basics of buy-sell agreements. There's normally the design, the insurance funding, and there's many different ways that you can do that. So if you can touch on that as well, that'd be great.
Yeah, absolutely. And it's a pleasure to be with you today, Rob, as well as Cory and our attendees. And I'm glad, Cory, that you asked the question, just to take a step back, because when we talk about buy-sell agreements or shareholders agreements, I'm presuming that most of our attendees are familiar with what we're talking about there. In my opinion, as far as business continuity, where there are more than one owners in a company, having some sort of an agreement is in my opinion, one of the most critical documents that owners will sign. So when we talk about a shareholders agreement, whether it's a buy, sell, a stock redemption, a member control agreement, for example, with an LLC, it's a legal document that basically offers the following advantages. First and foremost, it restricts the transfer of stock or partnership interest or membership units. It restricts the transfer except as provided within that agreement. Another benefit is that it creates a ready market for an owner's interest in a closely held business at certain triggering events. The triggering events can be death, disability, departure, under good or bad terms. It could be divorce, it could be bankruptcy, it could be voluntary retirement. Whatever the triggering event is, it creates a ready market for the owner. And in the event of a triggering event, it specifies who's the buyer, will they have the choice, will they be obligated, and what particularly are the agreed upon terms, price. If it's not going to be cashed out, what are the terms of a promissory note? So the value of the agreement itself provides that a family of a deceased or disabled or retired owner is going to have, particularly with a death or a disability, liquidity rather than ownership in a non-marketable business interest. Because the last thing most owners, family or spouse want is to have to step in and presume the responsibility that the deceased owner had. So the plans, shareholders, buy-sell, membership control, they're really designed not only for the owner and their family, but also for the business, for its employees, for customers, for any other co-shareholders. And again, in my opinion, make the buy-sell agreement, by all means, one of the most critical documents to be created and maintained. Now, to also put some context in this, Cory, can I share my
Yep.
screen?
That'd be great. You should, yep.
Okay. Let me do that. Because this does, when we talk about the different structures for these buy-sell agreements, and I'm going to use that term generally speaking, we've got basically, there's many. You've got the entity redemption, you've got a cross purchase, you've got a partnership, and you've got a one-way buy-sell. You also have a trustee cross purchase. You have a wait and see. But basically, when we talk about the different types of shareholders agreement, there are basically these. Connelly case had a stock redemption, and I know it's been meant, and let me go. Here's the entity form. The entity form is an agreement between the operating business and the business partners. So in other words, the operating business and the business partner, they enter into an agreement. The operating business is the one that purchases and pays for life insurance, insuring the various business owners. Now, I'll take just a step back. One of the things I kind of passed through, when we talk about these shareholders agreements and this obligation to purchase at a set price, the question often comes up, well, how is it that they're going to pay for it? Well, you've got a couple of choices. You've got company cash flow, if it exists. You've got bank financing, which could be questionable in the event of an owner's death. And then you've got the use of life insurance. Certainly don't have to utilize the life insurance, but the advantage of utilizing life insurance to fund the terms of your buy-sell agreement is that you've got complete financing is guaranteed from the onset. Death proceeds are received tax-free from both federal and state income tax, provided they're structured properly. Premiums are usually paid, the total amount of premiums are a fraction of what the death proceeds are. And in general, having an influx of capital is going to improve or enhance the business's credit position at a time when it may be weakened. So the entity purchases, again, company is the owner and the beneficiary. Upon a deceased shareholder's death, what ends up happening is that the insurance proceeds come into the business. The business turns cash over to the deceased partner's heirs. The deceased partner's heirs don't have a choice. By terms of the agreement, they have to turn the stock back to the operating agreement. And now the only outstanding shareholders are the survivors. That's how a typical entity redemption agreement works. And the key here is that, as Rob has mentioned, the life insurance going into the operating business. The one thing I'll note is that when the company is making the redemption, the surviving shareholders' cost basis in their business has not changed. They haven't paid any more. If I've got a 50-50 ownership and if my shareholder dies, I've just gone now from a 50 to 100% owner. The other option is a cross purchase. And this is where you've got an agreement between the partners in a company. The partners are in a cross purchase agreement. Life insurance is funded. It's an arrangement involving where each owner is the owner and the beneficiary on a policy insuring each other. You'll see basically we've taken out the operating agreement in this format. In other words, in the event Partnership A, Partnership B pay premiums directly to the life insurance. By terms of the agreement, they're going to utilize that upon a death. So now let's say we have a deceased partner. The life insurance company is going to pay tax-free death benefits to the surviving partner. Partner turns the cash over to the deceased shareholder's heirs. Deceased shareholder's heir turns the stock back over to the surviving partner. That's by terms of the agreement. Life insurance is just simply funding this agreement. But the beauty of this arrangement is that it's the other partner, it's the shareholder that is the recipient of the insurance proceeds. So they're paying for their stock redemption and gaining an increase in their cost basis with this arrangement. So this is an advantage, a clear advantage over the entity. We've taken the business. The problem with the cross purchase in a nutshell is that if you've got multiple owners, each needing to own life insurance on the other shareholder, the number of policies becomes laborious. In other words, if you've got the formula is you take the number of shareholders minus 1 times the number of shareholders, and that's how many life insurance policies have to be in play. So if you've got 4 owners, you've got 12 different contracts that are in play, and it becomes cumbersome. The option or the alternative is what they call a hybrid buy-sell, where a limited liability company is basically established. A limited liability is established, separate from the main operating business, taxed as a partnership using cash-based accounting. The partners create a cross-purchase agreement requiring each partner to purchase deceased business interests. Now, the operating business makes dividend distributions, compensation bonuses, loans, etc. for the own, and then the owners then contribute the funds to the LLC. The insurance LLC applies for and is the owner and the beneficiary of like one policy insuring each owner. And upon an owner's death, the insurance LLC receives death benefit, income tax free, distributes the proceeds to the surviving members, who then use the proceeds to purchase the ownership interest from the deceased estate pursuant to the cross purchase, resulting in an increase in tax basis equal to the purchase price. You know, the benefit of the LLC, if you will, the buy-sell LLC, is that only one life insurance policy per owner, like an entity stock, but provides an increase in cost basis like a cross purchase. So definitely the arrangement and who owns the insurance funding is of critical and this is part of the issue that we had, and we'll talk more about it. But so that's your 101 on buy-sell agreements. Everything you ever wanted to know, Cory.
It almost gives me a headache watching
right.
all the diagrams and arrows going all the way around. But it definitely it all ties back to even the Connelly versus U.S. Case. And I can't emphasize enough that in dealing with this, definitely make sure that you're having a conversation, just not with legal or tax, but both the parties at the same time, so you can work through any issues. And as you can see, it isn't just one path. There's multiple paths, and what's the right fit for you. But staying on kind of the buy-sell agreement, this doesn't necessarily tie back to the Connelly versus U.S. case. However, business valuation within the buy-sell agreement can be potentially an issue as well. And again, just you should take time to review that and regarding even clarity or different methods. And Dyanne, can you kind of talk about that kind of over and
And actually, I will tie this back to the Connelly because this is part of the issue. Not only did they have the life insurance that was payable directly to the operating business, but the real problem, I believe, that happened in this Connelly case. Well, let me take a step back. Identifying a valuation, a purchase price in the agreement probably offers the greatest potential conflict when it comes to creating this obligation and determining a purchase price. There's 3 common methods. There's others, but the 3 most common is within the agreement, there may be a stated formula For example, a certain multiple of EBITDA, earnings before income taxes, depreciation, and amortization. Or they could state that the value is going to be determined by appraisers upon the occurrence of a triggering event. The third most common method is a fixed or stated value with the idea that it's going to be updated on a regular basis. Now, while a stated value is the simplest, it also represents the highest potential for conflict because of the ebbs and flows of the business. And unless the owners all agree on an annual basis to this new value, highly likely that the original stated value is not going to represent the business fair market value. And that was the problem in Connelly. The problem is that their agreement provided a stated value of which there was no record of a signed off value agreement. And even though it had a backup for appraisal, as Rob had mentioned, they didn't go out and get an independent appraisal. They just determined, hey, we've got this insurance, we'll call the value at, 3 or 3.6 million. And here was, Michael's percentage. So, and those two issues, they hadn't had a stated value that was agreed upon. They didn't go out and get any sort of a third-party opinion as far as an appraisal goes. And that's where the IRS came in and said, hey, wait a minute. You guys are not mustering or passing this section 2703 of the IRC key that says, particularly in family-owned businesses, that the IRS will disregard the valuation unless it's a bona fide arrangement, it's not a device to transfer ownership to members for less than full and adequate consideration, and it contains terms that's comparable to unrelated parties in an arm's length transaction. And in this case, again, that was what the problem was. The IRS challenged this and thereby ended up concluding that while this insurance, which typically the receipt of which is offset by the obligation for the corporation to buy, it was an unfair valuation, and we're going to err on the conservative side. We're going to add the insurance to the valuation, not only for the purpose of redemption, but also for the purpose of estate tax calculation. So, one thing is if you've got a fixed or a formula is used in the, try to incorporate verbiage that says, hey, we're going to exclude any life insurance death proceeds that come in. That would be my suggestion.
Yeah, and again, on the valuation side, internally ourselves, we have multiple service lines, multiple entities, but that was a big subject for us to go through because the business valuation methodology that was really put in place 20 years ago and reviewed about 10 years ago and today is a lot different. So just going through and having that conversation with all the parties that are all the partners involved, and having that conversation, determining what is the fair method. And one thing you make me think of is I have two brothers that went into partnership on a real estate on operating company which leased the real estate, and the partnership agreement on the real estate said the buyout value was this dollar amount. Well, fast forward 40 years later, do you think that real estate is still worth what it was 40 years ago? And yet
and that's not unusual, Cory, because a lot of times owners don't revisit those agreements until they're forced to, a triggering event. And then they find out, oh, geez, should have dusted this off a bit ago.
Yeah. Yeah, and that was a particular case. One of the brothers passed, they read the agreement, and the other brother's like, yep, I'll buy you out for that. And it's like, now you've got family.
Right.
Yeah, so I can't emphasize enough just revisiting your buy-sell agreement, all the components with your key advisors, both the CPA and attorney going through that. Maybe, Rob, can you touch on what's really impacted by the Connelly or decision, in regards of design, structure, the shareholders, the insurance?
Yeah, excuse me. So I'd say if you represent privately held businesses with multiple owners, if you are an owner of a privately held business and there are multiple owners that you're standing shoulder to shoulder with, this is a 5 alarm fire for you and your clients. You really want to make sure that you're reviewing your buy sell agreements. Um, Generally speaking, I think the absolute longest you should go without having a conversation about your buy sell is maybe 5 years. But frankly, I recommend that business owners review it annually because things change and you want to make sure that your buy sell agreement is in line with current law, in line with current understanding and expectations, because as I'm sure you all are aware, things change, right? So and so's son or daughter was expecting to step into their shoes when they die or retire. Well, things change and maybe they're not interested in doing so anymore. Anytime that there's a fundamental shift in succession planning expectations is a great time to review your buy sell. Anytime you have new folks coming into the business in an ownership capacity, you want to review the buy sell. Anytime someone leaves, another great time to review that buy sell. You really want to make sure that you're being proactive about that. I can't tell you the number of times where I have conversations with clients and they're like, oh, we probably don't need to review our buy sell. We've had it in place for a long time. I'm like, well, maybe shoot it over. I can take a quick peek and just make sure that there's nothing else that needs to get touched up. And then, client sends over the agreement and it was typed on a typewriter. Generally speaking, if your buy sell agreement was typed on a typewriter, it's probably worth your time and money to have an attorney review that and make sure that everything is kind of up to par. I'd say, if you are an individual, whether, an advisor, an owner, or an executive, if there's company-owned life insurance or, any kind of self-funded life insurance to ensure continuity in a buyout context, absolutely worth reviewing your buy-sell agreement, worth reviewing your life insurance schema, really to make sure that it complies with this Connelly decision. Because if you don't, and I'm sure the folks who are with us today on this webinar are paying attention, but if you're not paying attention, you can find, upon the untimely death of one of the owners, you can find yourself hit with a multi-million-dollar tax bill, and that's not something that anybody wants to deal with. Now, thankfully, the most recent bill that passed through Congress, the big beautiful bill, it raised the estate tax exemption up to, correct me if I'm wrong on this, Dan, but I believe it's 15 million.
15, absolutely.
So,
increased it.
So this is, the risk of the Connelly decision on folks who own privately held businesses on the smaller end is probably lower than it was before that bill passed. But even if you're anywhere close to that $15 million exemption, it is absolutely worth your time, money, and attention today to review your agreements, to review your life insurance setup, to make sure that your plan is set up with this in mind, to make sure that you're not going to get hit with an accidental, surprising bill that will materially alter your estate planning and succession planning for your business. Absolutely essential. And I can't recommend it strongly enough.
Yeah, no, I agree with that. Even internally now, we've set it up where we do an annual review of not only that, but even the insurance, life insurance coverage. Is it adequate, inadequate? Do we have all the people covered? And then probably just as important, I think, as well as, let's say if you're nearing that retirement age, I'll say 55 and plus, just because I'm on the other side of that number, understanding what your buyout is.
Mhm.
And then how does that fit into your retirement plan? Because for a majority of our clients, it's a significant asset for them.
Mhm. Mhm.
And even if it's both the partners are exiting at the same time, to have a general idea or a good idea of what their organization or their investment's worth. So I can't speak enough to that, just about the buy-sell agreement. And I think it's a minor investment that you should be making in reviewing that document, updating it. And somewhat embarrassed to say, but it was one of my partners that came back with the Connelly case and said, I got this from my insurance broker and we should be looking at it. So that's what really brought it on our side. And it actually kind of tipped the conversation here with the three of us was, oh, if this is news for us as an organization, then it has to be news for all of our clients or other relationships that we have out there. So I don't know if we missed anything, Dyanne or Rob, that,
I would just add, in addition to, I think, what Rob and you, Cory, have mentioned, the idea that I like your term, Rob, the 5-alarm fire. Given all the potential issues with the entity redemption arrangements funded with the company-owned life insurance, in my opinion, entity redemption arrangements, in my opinion, should be a company's last resort, even for the business owners who don't approach having a taxable estate, because a company could still have an entity redemption plan, but keep the ownership of the life insurance outside of the business. For example, if a buyout is structured as an entity redemption upon a shareholder's death, the life insurance proceeds received by the owners outside of the business could be used by the owners to make a capital contribution or even a loan to the business so that the company can redeem the deceased owner's interest. So you can even still have your stock redemption, but I highly would encourage owners out there, if you've chosen to fund it with life insurance, if there's any way for you to have ownership and beneficiary outside of the operating agreement. We talked about that partnership being one of them. Highly, highly recommend that you challenge your advisors as well and just say, hey, is this something that we should be concerned with? Because that's what's going to bring about a review and potentially save hundreds of thousands on the redemption price and the estate tax inclusion. So just like what you had said, Cory, and what you've said, Rob, I mean, I think this is a wake-up call for any owner with a stock redemption buy-sell membership control agreement in place.
yeah,
And I would also echo that. Well said, Dyanne. But another thing to consider too is to have ongoing annual valuations,
Mm-hmm.
semi-regular valuations. It's not a binding portion of the Supreme Court's decision, but they did kind of embed in a footnote, if they had a professional valuation done and the professional valuation was set at the price that the company ultimately redeemed those shares back from the deceased shareholder's estate, that could have potentially saved the estate from paying a large estate tax bill. But because it was a pick a number case, because it was less than what the IRS ultimately determined to be fair market value, they were able to ignore the obligation on behalf of the company.
Yep.
They were able to ignore that contingent liability in valuing the shares of the company that were held by the deceased shareholder. So if they had done what I think is a pretty reasonable, prudent act by, privately held business, every once in a while, let's just get a professional valuation done. And I recognize that they are time consuming, relatively expensive, but it creates clarity. And when you have a recent professional valuation, the IRS occasionally will attempt to challenge it, but it's a much, much harder argument to make for the IRS. It's an uphill climb. If you have a professional valuation, the IRS tends to, and I'm not going to say always, but they tend to rely on that. They tend to say, okay, that seems fair and reasonable, unless it just missed certain things. But that's probably not likely if you're getting professional valuations done.
And and I would add to that, Rob, that just another consideration, and you're absolutely correct, having an updated valuation. But the other thing for owners on the webinar to understand is that you can also identify or differentiate valuation methods based on the different triggering events. In other words, the price paid for purchasing shares from the spouse of a deceased shareholder doesn't have to be exactly the same as the price paid for purchasing a shareholders who was terminated for cause, for example. So, yes, you want to have an outside opinion and you want that valuation done regularly. But the other just nuance is that, also keep in mind that you can apply potential discount based on particular triggering events. So just another thing to add.
Yeah, just to add a little color in regards of business valuation, there's IRS regulations that there's requirements or a process in determining the value. So again, when our certified business valuation professionals prepare a report, they're following those guidelines. So normally it isn't the overlying theme of the whole valuation. It might be a discount component or implied minority interest discount, things of that nature that you're really battling on, not the core value. So it normally isolated down to a few components that you're arguing with the IRS, as long as you're being following those rules and regulations, which majority of all certified business valuations are all prepared in alignment with those. And then you just make me think of another item is where there's a business that there's a 90% shareholder and a 10% shareholder, and they have a buy-sell component to it. But really, when the evaluation was done, there was a minority and a control risk discount being applied to the 10% shareholder. So part of it is making sure that everyone understands, even the minority shareholder, this is the valuation of your ownership. It isn't necessarily always just 10% of that number. So there's an educational and agreement meeting of the minds of all the parties involved. So again, just reviewing it, understanding, making sure that it's current versus something that was set in the past, and then you're in good shape. And especially, again, do we have the life insurance in place? Do we have it structured the most efficient way? And again, when I look at part of our value that we bring to clients is minimize income tax and minimize estate tax. So that's a win for your family and a win for us, and fair, I think fair with the IRS in the state of Minnesota. So
yeah, you never want to be in a position where you're arguing with the IRS. Although it happens.
Yeah, and again, we've had that on business valuations on large enough estates that we know that there's going to be a conversation around it, and that we just have to be able to defend our position. And normally it's something negotiated, but it's still to the benefit of the estate and the surviving family or the surviving spouse. So I do not see any questions. So on that note, I hope that individuals got something from this conversation. As usual, I always pick up something, and I really do appreciate Dyanne and Rob, you taking time out to have a conversation around this subject. Is again how important it really is for our clients that have multiple ownerships. And then just for everyone that registered or is listening, we will be emailing out to everyone a recording of this webinar, as well as contact information for both Dyanne and Rob if you do have any further questions for them subsequent to this webinar. Just reach out and they'd be glad to help you. Again, thank you for your time, Dyanne and Rob, and appreciate it, and have a good rest of the day.
Thank you, Cory. Thank you, Rob.
Thanks, Cory. Thanks, Dyanne. Thanks, everyone, for attending. Have a great rest of your day.